Hello, everybody. My name's Evan Farr, and I will be talking to you today about how to protect your assets from the expenses of probate and long-term care. For those of you who don't know me, let me tell you a little bit about myself, and you can see this on the screen in front of you. I'm one of about 570 certified elder law attorneys in the country. I've written 4 best-selling books in the field of elder law. I'm a top lawyer as rated by all of the legitimate rating agencies in the country, including locally with Washingtonian Magazine and Northern Virginia Magazine. Um, and I'm the creator of the Living Trust Plus asset protection system, which is used by about 40 to 50 attorneys around the country. And that's part of what we'll be talking about today. But let me tell you a little bit about my firm as well. Our firm has been around since 1991, helping protect folks like you. We serve all of Virginia, Maryland, and DC. We have offices throughout the area in Fairfax and Fredericksburg on the Virginia side, Rockville and Annapolis on the Maryland side, and also in DC. We have about 14 team members at any given time. And our firm does everything we're going to be talking about today, of course, and a lot more. Everything to do with elder law, estate planning, trust administration, probate, guardianship, special needs planning. One thing we don't do is contested litigation. Life's too short. We try not to get involved with anything where we know it's going to wind up being contested. We like working with happy families where people get along. All right, so getting right into the information. Actually, first of all, before we get into the information, if you do have any questions as I'm talking today, please use the Q&A tab on the bottom to ask those questions, and I'll get to those at the end of the webinar rather than interrupting during the middle. Excuse me. I will try to answer all the questions at the end. Sometimes people ask questions that are too fact specific or too complex to answer in the context of this type of webinar. But of course, we offer personal consultations, and you're, of course, welcome to make an appointment to have your specific or complex or fact specific questions answered. All right, so now we'll get into the material. When you think about long-term illness, what are some of your worst fears? Well, if you're like most of our clients, some of your fears revolve around winding up in a nursing home and running out of money. And those two things often go hand in hand because nursing homes are extremely expensive in this area, $14,000 to $16,000 a month. And many people who wind up in a nursing home do run out of money. But part of what you're going to be learning about today is that you don't have to be one of those statistics because there are a lot of things you can do to protect your assets so that you don't run out of money if you do wind up in a nursing home. We can't help on the medical side, unfortunately, with the memory loss. I know that's a big fear for a lot of people, but we do have a newsletter and a blog with lots of helpful articles about cutting edge medicines and new treatments that have come out over the years, and you might want to check that out. If you're not already receiving our newsletter, I encourage you to visit our website at farlawfirm.com and sign up for our newsletter. You can also get some of my books when you sign up. All right, a pop quiz. We said this is going to be about protecting your assets from probate and long-term care. So let's start with probate. What do you think probate looks like? Is it the happy gentleman on the left, where the older gentleman's telling the younger one, here's all you need? Or is it the maze of wandering people on the right, where one guy up top is wondering, do I really want to jump into this maze? Well, of course, the correct answer is the maze. Probate is not just a maze, it is a nightmare. In fact, typically when you hear the word probate, it's in conjunction with the phrase, the nightmare of probate, because it really is an overly incredibly complex process involving court filings, starting with a qualification of an executor after probating a document, or it may not be an executor. We'll talk about that later. Um, Inventories have to be filed typically 4 months after probate is open, showing all the assets of an estate. And then we have the dreaded annual accounting, which has to be filed 12 months after the inventory. So we're now 16 months after the probate starting event. And then that accounting has to be filed every year as long as probate remains open. And there is no limit to how long probate can remain open. And these annual accountings are so complicated because they have to balance to the penny. It's an itemization of all the money coming into an estate and all the money going out during a 1 year period. And it has to balance to the penny. And people spend typically 40 to 60 hours going through to prepare these annual accountings. And often they get to the end and there's a discrepancy. Maybe it's only a 3 cent discrepancy, because maybe somewhere among dozens of bank statements, perhaps many dozens of bank statements. Imagine you have 7 accounts in probate with 12 monthly statements. That's what 7 times 12 is 84. So that's 84 monthly statements with just 7 accounts. You've got to now go through all of those 84 monthly statements with a fine-tooth comb to figure out where was the 3 cent mistake. Maybe the bank's optical scanners misread an 8 as a 5 or a 5 as a 2. Two of the most common mistakes that are still made despite optical scanning getting better and more sophisticated. So if you have to go through with a fine-tooth comb and spend another 40 to 60 to 80 hours to track down that 3 cent mistake, so be it. That's what you've got to do, or the commissioner of accounts, part of the probate court, is going to kick the accounting back to you and say, fix it. All right. Probate is part of the court system. There's judicial oversight that goes along with this whole process. And because there's judicial oversight, it's very easy for people to contest something going on in probate, like filing a will contest, claiming that a will that's been admitted to probate was procured through undue influence, or the person who signed the will was incapacitated when they signed it, or being manipulated. Very easy for anyone to come in and file a will contest. Probate's also expensive. General cost around the country is 5 to 8% of the estate. Imagine what's now in this DC metro area kind of a normal estate of, let's just say, $1 million. Well, that's $50,000 to $80,000 in probate fees and expenses. Part of that is taxes, part of that is filing fees. All of it is aggravating red tape, delay, and aggravation. The delay is it takes typically at least a year for probate to finish, and often, as I mentioned earlier, there may be no end in sight. There's no limit to how long probate can go on. And all of this is unnecessary because there are simple ways to avoid probate. But first, another pop quiz. When does probate occur? Is it during your lifetime, after your death, or both? During your life and after death? Think about it. The correct answer, the most correct answer is C. If you answered B after death, you're not wrong. And because most people, when they think about probate, they think about it after death. But the more correct answer is both. Now, your question is, why would you have probate during your life? And the simple answer is incapacity. If you become incapacitated while you're alive and you can no longer make legal and financial and medical decisions for yourself, and if you don't have the proper document in place or documents, which we're going to talk about in a moment, someone's going to have to go to court and have you declared incompetent to be and become appointed as your guardian and conservator, thus beginning the process of lifetime probate, requiring your guardian and conservator to file annual accountings for the rest of your life every single year. And that's why after or lifetime probate is often, usually even worse than after death probate. After death probate would typically only lasts about 2 years. It can go much longer. There's no limit, but lifetime probate is often something that goes on for 5 years to 40 years. I mean, depending how old someone is when they become incapacitated without the proper documents. Guardianship and conservatorship can be a very long-term thing with these incredibly complex accountings having to be filed every single year. So this whole lifetime probate nightmare, again, is usually worse than the nightmare of after death probate. The good news is that this whole lifetime probate, guardianship and conservatorship, is a last resort process. This is not something you want to rely on. It's not something you want to ever have to do um, for a competent adult. Now, there are parents who have children with special needs, and when those children turn 18, we have to do a special type of guardianship and conservatorship called a coming of age guardianship. And that's unfortunately sometimes just a necessity, although not always a necessity, because some coming of age young adults are able to sign documents, which we're going to talk about in a minute, where they don't need guardianship and conservatorship. So even then, it's somewhat of a last resort. Um, but this whole process of guardianship and conservatorship requires notice be given to all the family members involved. It can be challenged. Somebody, if you're petitioning to be guardian and conservator, someone can come in and say, you're not qualified. You shouldn't be the guardian and conservator. Someone else should be. The person who is allegedly incapacitated may challenge it and say, I'm fine. I don't need someone making decisions for me. The court-appointed attorney, typically called a guardian ad litem, can challenge it, saying that they don't believe the person is incapacitated, or they don't believe the person seeking to be appointed is a proper person to be appointed. So there's all kinds of ways these can be challenged and make this whole process a nightmare. And again, once it's granted, that means annual accountings until the death of the ward. The person who is declared incapacitated is technically a ward of the state, and the guardian and conservator is basically appointed by the court to represent the state and report back to the estate every year on how the ward is doing and how their money is being spent. You don't want that. We don't want to ever have to go through this if we can avoid it. And there's an easy way to avoid this lifetime probate through what we call incapacity planning, or what we call in our firm level one planning, because it's the most basic type of planning. This is all about signing specific documents that name someone to handle your legal and financial and medical affairs when you're not able to. And I'm sure a lot of you already have the most important legal document of all, which is the general power of attorney. If you don't, you need one, because this is what avoids the conservatorship. It avoids that whole living probate filing of annual accountings, because you're naming somebody to handle your legal and financial affairs if you become incapacitated. But it's not good enough to run out to Staples or Office Depot or go online to Legal Doom or Rocket Liar, and I may have mispronounced those a little bit, um, and download or use one of these off-the-shelf forms for a power of attorney, or Susie Orman. I think that's still a thing. She sells forms. The I was very saddened to see AARP recommending, one of their sponsors is Trust and Will, which is an online form factory. The problem with all of these online form factories is they're not attorneys. They don't know your specific needs and wishes. And they certainly don't know that you want a power of attorney that has asset protection powers. And the reality is 90% of power of attorney documents out there do not have asset protection powers, which I think, as an elder law attorney who does asset protection every day, are critical. I think your power of attorney needs to have the ability for your spouse or your children to do Medicaid planning, including the ability to do unlimited gifting, which is often needed as part of asset protection powers, and the ability to create and fund all types of trusts, both revocable and irrevocable trusts, even irrevocable trusts that aren't technically for your benefit, which is the main type of asset protection trust that we'll be talking about today, and the power to revoke trusts. So, our power of attorney, and the power of attorneys done by most experienced elder law attorneys, have all of these asset protection powers and more. But most power of attorney documents do not have these powers. And so again, you want to make sure you've got not just any old power of attorney, but a good power of attorney done by an experienced elder law attorney. The second document that's part of level one planning is the advanced medical directive. This is what avoids guardianship, because you're naming someone in advance to make medical decisions for you if you're unable to make medical decisions. So there's no need for a guardianship to have someone appointed to make medical decisions for you. The advanced medical directive needs to be HIPAA compliant, of course, which means that doctors can talk to the people that you've named in your document and reveal your confidential financial information. And there's lots of different advanced medical directives out there. And by the way, sometimes you'll hear other terms like living will, which is an old-fashioned term for an advanced medical directive. You'll hear medical power of attorney, you'll hear healthcare surrogate document, lots of different names. But the modern name for these documents is advanced medical directive. The specific name for the one we prepare, that's proprietary to my firm, that I created and have licensed to attorneys all around the country, is the Four Needs Advanced Medical Directive. And we'll look now at what those four needs are. The first need is a medical power of attorney. This is where you name somebody to make medical decisions for you if you are unable to make medical decisions for yourself. This could be anything, um, consenting to surgery or medical procedures, or terminating medical procedures, or according to your wishes, and anything where you might make a decision. This allows somebody else to make a decision. The second part of this document is, again, proprietary to me and my firm. That's the long-term care directive. This is something that I've created and developed and fine-tuned over the years. It's part of the advanced medical directive. It's also a separate standalone document that is all about helping you get the best long-term care if, God forbid, you find yourself in a situation where you are bedridden, perhaps from a massive stroke, and you can't make decisions for yourself because you can't communicate is often the situation. When you've had a serious stroke, you're paralyzed on half your body. It very frequently, almost always, takes out your ability to speak, or your ability to speak clearly so that people can understand you. And this long-term care directive becomes your voice in that scenario. It tells people who you are as a person and what are your likes and dislikes and preferences and habits. Things like food, dietary preferences, dietary habits, like what types of foods do you like? What types of foods do you hate? Um, do you have certain habits with food or beverages, like starting when you wake up in the morning? Do you drink coffee? And if so, how many cups do you drink, and how do you take your coffee? Or if you're a tea drinker, what of the 1,000 different types of tea, what type do you like? Um, Throughout the day, do you like a hot breakfast? Are you a cereal person? Do you like a hot lunch, or are you a cold sandwich person? Um, you know, there you may not always get everything exactly the way you want it, but it really helps if people know these things about you, because there often are choices, especially if you're getting in-home care with an in-home caregiver and you have children or other loved ones who have looked at your long-term care directive and given guidance to your caregiver. This is what mom wants, this is what dad wants, because here it's spelled out in their long-term care directive. It gets into daily activities. Okay, if you're bedridden, again, whether at your home or in a nursing home or an assisted living facility, all you can do is sit and passively absorb entertainment. Well, what kind of entertainment? Um, do you prefer movies, TV shows, audiobooks, music? Maybe you like all of them, but maybe you have specific preferences, as most people do, within movie genres, specific types of books. Maybe you're a history buff. Maybe you like science fiction. Maybe you like fantasy. Of with movies, maybe you like certain actors, certain directors. Maybe you prefer audiobooks versus having somebody read to you. I mean, the list goes on and on. Um, as far as daytime activities and the types of things you would enjoy the most. The long-term care directive gets into grooming and hygiene preferences, like what types of soaps and shampoos and lotions and lip moisturizers you prefer, um, deodorants, uh, everything to do with grooming and hygiene. The The long-term care directive gets into sleeping preferences. Do you sleep on your back or on your side? How many pillows do you like? Do you like firm pillows or soft pillows? Do you like multiple pillows? Do you sleep on your side with a pillow between your knees, or do you sleep on your back with a pillow under your knees? There's so many different uh, specifics that people have preferences for, and some of you may be listening to this and thinking this is absurd. Are there really people that high maintenance? Some of you may think that, and others of you are thinking, yeah, he's talking about me, and I know, I want someone to know my preferences. I'm very picky, and if you can make your preferences known, and possibly get the type of care you want. There's no 100% guarantee, but if you have somebody looking out for you, the chances are better than not that they're going to help make sure that your long-term care directive gets followed and that you have a decent quality of life instead of a potentially terrible quality of life in an already terrible scenario where, you're bedridden and can't communicate. Ah, moving on, the third need, that's part of the four needs advanced medical directive, is the near-death directive. This is obviously applies to people with like terminal cancer when they're near death or they have some other illness, maybe late stage dementia where they've stopped eating and they're nearing death. This part of the document is what used to be called the living will, which used to be when it first came out, like in the late 80s, the living will was a one size fits all document that said, if I have a terminal condition, pull the plug, don't keep me alive. And maybe that's your wishes as part of your near death directive, but maybe it's not. Maybe your wishes are slightly different. Maybe they're very different and you do want to be kept alive at all costs. Most people don't want that, but many people have sort of in between wishes like, well, if it looks like I'm terminal, keep me alive at least for enough time for my family to all come and gather and say goodbyes before you just discontinue the treatment. That's what a lot of people say. But yours can be customized to exactly how you want it. This whole document is very, very customized to your specific desires. And the last part is the after death directive. This is where you specify whether you want to be an organ donor, whether you want to be cremated or buried, how you want your bodily remains disposed of, whether that's going to be buried somewhere or ashes sprinkled somewhere. You can write your own epitaph. You can write your own obituary. All kinds of stuff that have to do with after death wishes gets put into your after death directive. All right. Another pop quiz. Does a will avoid probate after death? Excuse me. If you're like most people, well, if half of you are like most people, about half of you probably thought the answer to this question was yes, that a will avoids probate. But probably all of you are in the smarter camp, and probably all of you realized that the correct answer is no, that a will does not avoid probate. In fact, a will causes probate. A will is a ticket straight to the probate court. In fact, a will only becomes valid and effective as a will once it has been admitted to probate. Remember, the full name of a will is a last will and testament. You can change your last will and testament 100 times. And whichever the last one is before your death, that's the one that's going to get probated. And once it's probated and acknowledged to be your official will, that starts probate. Why do people want to avoid probate? Well, the pain and confusion and head scratching and the nightmare that we've already talked about. It truly is not something you want your loved ones to have to go through. And again, we have good news. Just like we have level 1 planning to avoid lifetime probate, we have level 2 planning to avoid after death probate. So this builds on top of level 1 planning and includes level 1 planning, but level 2 planning adds in a revocable living trust. This is typically done by adults in the midst of life, 25 to 65. And the whole purpose of a revocable living trust is to protect your assets from going through probate after death. The way it does that is that the trust is an entity that you create by signing a document, a trust agreement. It's basically an agreement that you, as the creator of the trust, make with yourself as the trustee of the trust. The trustee manages the trust for the benefit of the beneficiaries of the trust. Well, as long as you're alive, you, and when I say you, it's you and your spouse if you're married, you are the beneficiaries of your own trust. So you're managing the money and your assets for yourselves while you're alive. And nothing changes in your life. It's just a document that uh, is technically an entity that owns your assets, but nothing changes with the way you live your life, pay your bills, file taxes, etc. What changes is that the idea when you have a revocable trust is you retitle your assets into the trust. That means, for instance, with your real estate, we prepare a deed putting your house into the trust. For your other assets, your financial accounts, you go online or you call your investment institutions, or you go to the bank after you've signed your trust and you tell them, hey, I'm setting up a trust, or I've set up a trust and I want to retitle this account into my name as trustee of my trust. Now it's in the trust and you're going to start getting statements in your name as trustee of your trust. And the trust has instructions in it that say, upon my death, here's where the assets go. And those assets can go to whoever you want, just like they could through a will, but they avoid probate because wills go through probate. Now, the trust also avoids multi-state probate. This happens much more often than people realize, and it happens when people own real estate in more than one jurisdiction. I'm sure many of you have your primary home here in the DMV. I'm guessing most of you live here in DC, Maryland, or Virginia, um, where you have your primary home. But if you're like a lot of our clients, you may have a second home in another state. Maybe it's a property that you used to own and you converted it to a rental property. Maybe you purchased a second home and use it as a second home or a rental property. Maybe you inherited a partial interest in a piece of property in another state where that from your parents or grandparents. If you don't put that real estate into a trust or an LLC or some other entity, it's going to go through probate in the state where it's located. So a trust is often used to avoid multi-state probate. Trusts also provide financial privacy. And this has become more important, more and more important these days because of identity theft and all the scammers out there, con artists that target um, seniors, they target widows and widowers. They go through probate records that are public records to see, oh, here's an inventory. This person died and they left a spouse and they've got $2 million. We're going to go start spearfishing and targeting this person. Um, Spearfishing is an email thing where scammers get your financial information and send very targeted threats or scams that look real to try to gain access to your bank accounts. And sadly, this is a multi-billion-dollar criminal enterprise in this country and around the world. And some of this is fueled by probate records because of all that financial information being public. With the trust, it's completely private. So it helps a little bit to avoid some of the cons and scams and phishing and identity theft that's so rampant out there. Now, after you die with a revocable trust, and by the way, this applies with an irrevocable trust also, uh, because when you die with a revocable trust, that trust becomes irrevocable immediately upon your death. If you're an individual, if you're a married couple, it becomes irrevocable typically on the death of the second spouse to die. And that's because if you're dead, you can't revoke the trust anymore. So just as a natural consequence of no longer being alive, you can no longer revoke the trust. So it becomes irrevocable. And it can either terminate at that point, which is shown here on the left here and with the red graphics, where your trust terminates, the money goes outright to your children, so they can put it in a safe, but they have no protection from any of life's financial risks because it's just money they now inherited and they own. Or you can have the money go to your children in what we call beneficiary asset protection trusts. These go by many different names, including spendthrift trusts, dynasty trusts. That's typically a term used for, people who are very wealthy, but it's the same thing. It's basically a protective, self-managed trust, meaning each child can be their own trustee. They can manage the money for themselves. They can spend the money however they want. But if they don't spend it, if they leave it in their locked safe here, protected, the money that they don't spend is protected from everything: lawsuits, divorce, bankruptcy, medical bills, nursing home expenses, any of life's financial risks that may be thrown at your children or your other beneficiaries. Most of the time it's your children. But this can apply to whoever your beneficiaries are: grandchildren, nieces, nephews, friends, whatever. So this is a nice add-on feature to a revocable trust or an irrevocable trust to protect assets for your beneficiaries. All right. Now, what about joint ownership and beneficiary designations? A lot of people ask this question, and a lot of people think that joint ownership and beneficiary designations completely solve the problem of probate, and therefore, why would you need a trust? Well, let me tell you why. First of all, joint ownership is typically only between spouses. And yes, it avoids probate when one spouse dies, but it doesn't avoid probate when the second spouse dies unless you make your children the joint owners of your account, which is generally a terrible idea because if you make a child the owner of your account, first of all, if you have more than one child and you only name one child as a joint owner, we see this a lot. What you wind up doing is disinheriting your other children and causing a huge family rift. But also what you're doing when you add one or more children to your accounts is you're exposing your assets to all of their creditors. And, meaning not only the assets exposed to your creditors, but they're exposed to your children's creditors. So if they get sued, if they get go through a divorce, if they have to file bankruptcy or have catastrophic medical bills, all of your accounts get dragged into this mix because you've named your child as a joint owner on your accounts. Um, so joint ownership, not a good idea as a general rule, except between spouses. Now, what about beneficiary designations, which I abbreviate here as BDs? Well, those also are not a good solution for avoiding probate for a lot of reasons. Number one, they don't work for all types of assets. You can't name a beneficiary for everything. They're tedious to change. So let's say you have 10 different accounts at different financial institutions with different beneficiaries named, and all of a sudden you want to change your beneficiaries. Well, you got to now go back to all 10 different institutions and change your beneficiaries. It's hard enough doing it the first time, much less having to go back and do it again with 10 different financial institutions. And worse yet, you probably don't even remember who you named as your beneficiaries. Most people don't keep a record of that. They fill out a form when they set up an account. Nobody gives them a copy of that form, and it's lost to the paperwork of that financial institution. You might be able to request it, and the financial institution will hopefully be able to send you information on who the beneficiaries are. Some places have them online now, which is very helpful. And sometimes you can even change beneficiaries online, which is great. But it's still tedious to change, and they're tedious to keep synchronized. If a lot of people make the really bad mistake of, let's say you have 5 different accounts, and or let's make it 6 accounts. Let's say you have 3 children, you have 6 accounts. So you decide to make each child the beneficiary of 2 accounts. When I say account, it might be a retirement account, it might be a life insurance policy, it might be a brokerage account, could be anything. So, and you try to equalize it by, having the monies in there being roughly the same. Well, that's going to change. Your money changes. You spend money. You might completely spend one account. Maybe you're leaving an IRA to one of your kids thinking they're going to get the full amount. Well, they're not, because they're going to have to pay taxes on 100% of the money you're leaving them. So trying to do estate planning using those kinds of mishmash beneficiary designations is a mess. It's not a comprehensive estate plan. It's a recipe for disaster. Beneficiary designations don't work for minors. Minors cannot own assets, people under 18. And if they wind up owning an asset, they can't do anything with it. They can't spend it. They can't use it. They can't buy anything because they don't have the ability to handle money as a minor. Now, you may be thinking, this doesn't apply to you because maybe all of your children are adults. Well, excuse me, do you have any grandchildren? Is it possible one of your children may die before you, and all of a sudden a grandchild who is a minor becomes a beneficiary? Of course it is. You never know what's going to happen. And this points that out. Beneficiary designations don't work if the named beneficiary dies before you, because what happens to the money at that point? Does it go to their children? If they're a minor, now what? They can't do anything with it. It's going to wind up in probate. Or maybe it doesn't go to their children. Maybe it goes to their spouse. Or maybe it doesn't go to their spouse. Maybe it just disappears and it goes to the other beneficiaries you name. Maybe if you have 3 children and one dies, maybe the beneficiary designation paperwork says it all goes to the other 2 children. Do you know? Probably not. Again, because when you signed the form with the financial institution, it had its rules. And most people don't pay a lot of attention to those rules. And those rules may not be what you would want. So money may wind up going somewhere where you don't want it to go, including possibly to probate. You know, maybe the beneficiary designation says if a beneficiary dies, their before you, their share goes to probate, goes to their state. Well, so much for avoiding probate. Beneficiary designations don't work for disabled beneficiaries because disabled beneficiaries are typically on public benefits like SSI and Medicaid, which require that people have less than $2,000 of assets as a general rule. And if you come along and you die and you leave them money through a beneficiary designation, you've just knocked them off of benefits that they probably worked really hard to get on. Now, you may be thinking that doesn't apply to me. You don't have any disabled beneficiaries. And to that I say, you don't right now, but you might, because you never know when one of your beneficiaries might become disabled. Beneficiary designations also don't work if the beneficiaries are not aware that they're beneficiaries. There is over $100 billion of unclaimed property in our country because of failed beneficiary designations, in part because beneficiaries didn't know they were beneficiaries. A lot of parents are secretive about their assets and don't even tell their kids what the assets are, much less that they're beneficiaries. So, you know, there's a reason there's over $100 billion of unclaimed property in our country. And a huge part of that is beneficiary designations not working. They also don't work if the beneficiaries can't get access to your death certificate, because every beneficiary you name has to get an original death certificate, which are provided by the funeral home, typically to one person. If that one person doesn't choose to share them with other people, you've got a real problem, because now the beneficiaries can't go to the financial institution and fill out the claim form and prove that you're dead. Also, a huge, huge problem. And yes, that's what has to happen. You know, financial institutions, when you die, they're not going to, on their own, reach out to your beneficiaries and tell them, hey, beneficiary, your loved one just died and you're the beneficiary and here's your money. That is not how it works with any financial institution. It is incumbent upon the beneficiaries to know that they're a beneficiary, to know where your accounts are, to know your account numbers, to get your death certificate and to make an appointment and fill out the proper paperwork with the proper institution to make a claim. And hopefully, if they do everything right, eventually they'll get their inheritance. So beneficiary designations are not this seamless, magical way to transfer assets upon death that most people are falsely led to believe. So, as you can tell, I'm not a fan of beneficiary designations unless your beneficiary is your trust. And then that's fine, because your trustee is going to have information about all of your assets and your trustee can easily do the stuff that needs to be done. But typically, you make the trust the owner of your assets. But sometimes the trust will be the beneficiary, like for retirement accounts, where the trust cannot become the owner while you're alive, but you will name the trust as the beneficiary upon your death. All right. Let me move on here. All right, another pop quiz. Does a revocable living trust protect your assets when you wind up in a nursing home? I'm guessing some of you on this webinar have a revocable living trust, and I'm guessing that some of you are hoping the answer to this question is yes, but it's not. It's a big whopping no. And this is the big limitation of a revocable living trust. It's not a defect, it's just how a revocable living trust works. It's a built-in limitation. There is no protection from creditors with a revocable living trust, including no protection from the biggest and most likely creditor that all of us face in our lifetime, which is the nursing home or assisted living facility or other long-term care expenses like for in-home care. There's just no asset protection with a revocable living trust. The revocable living trust protects the assets from probate. That's it. The fact that it is revocable means that you can take all the money out. And if you can take all the money out, so can your creditors. They stand in your shoes. That's how the law works. Excuse me. So why do we care about this? Well, we care about it because of the ridiculously absurd expenses of long-term care and getting more and more expensive every year. I already mentioned nursing homes, earlier I said 14 to 16. It's, really, if we go all the way down to Fredericksburg area, there's some as low as 12,000, and there's some that are as high as 19,000 a month in the DMV. And actually, it's sometimes more than that, but there are nursing homes that are sometimes $35,000 to $40,000 a month, particularly if there are unusual medical conditions. Usually that's involving someone who's on a ventilator. That's where nursing home care is it's already absurdly expensive, but 35 to 40,000 a month is just, mind-boggling. Even 12 to 19,000 a month is unaffordable for most people for any significant length of time. Assisted living, less expensive, 6 to 12,000 a month in the greater DMV area, including, going all the way down to Fredericksburg, Virginia. Here, more locally in the DMV proper, the range is about 8 to 12,000 a month. And the holy grail of care that most people want, which is to age in place and stay at home and have 24-hour in-home care, that's a wonderful goal, but we're talking $20,000 to $30,000 a month to afford that kind of care. So again, it's doable for some people, but most middle class, upper middle class folks, don't have that kind of money where they can afford to pay for that, at least not for very long. And that's why people are worried about protecting their assets from long-term care expenses, is so that they don't have to go broke. Now, we talk about long-term care expenses. Let's define what I mean by long-term care. Long-term care is care that people receive to help them with activities of daily living. The activities of daily living are bathing, dressing, eating, self-explanatory. Transferring, that's getting out of a bed into a chair or moving from a standing to a sitting position, basically changing position, between lying, sitting, standing. Continence is the ability to remain continent, to not, have accidents of bowel or bladder. Or if you do have occasional accidents, but you're able to clean up after yourself and appropriately and put on new adult undergarments, then you don't need help with that ADL, activity of daily living. Toileting is similar, but uh, toileting is the act of realizing that you need to use the toilet, getting to the bathroom, properly using the toilet, properly cleaning up after yourself, etc. And if you can do all that by yourself, you don't need help with that activity of daily living. But many people, as they age or as a result of a stroke or dementia or other illnesses, they start needing help with these activities of daily living. And typically, when someone needs help with two of these 6 ADLs, that's considered that they need assisted living. And when someone needs help with 4 of these 6 activities of daily living, that's generally considered needing the nursing home level of care. And assisted living can happen in an assisted living facility or at home. And same thing with nursing home care. That can happen in a nursing home or at home. Now, an overlay to all of these physical problems are cognitive impairments, Alzheimer's and any other types of dementia. There's at least half a dozen different types. These can also cause the need for long-term care, from assisted living to nursing home level of care. One of the key factors that somebody with dementia might be experiencing that might require the need for nursing home level of care is if they would not be able to get themselves to safety in an emergency. If there were a fire and they were left alone, would they be able to call 911 or even call a family member? Or would they know to leave their home? These are safety issues that people with dementia often have a problem with. Dementia is one of the biggest risks for needing long-term care. 1 in 9 people over 65 have Alzheimer's, 1 in 3 over 85, most eventually needing nursing home. Strokes, 600,000 people a year. Someone every 45 seconds just in our country has a stroke, one of the main causes of needing nursing home care. Osteoporosis, also osteoarthritis. These are weak bones, brittle bones. People become at high risk for a fall. And when they do fall, they have a greater risk of breaking a bone, and a broken hip or a broken pelvis. If it is inoperable, which it sometimes is because it's a bad shatter, or maybe the person is just not a surgical candidate because they don't do well with general anesthesia, or they're too frail, or they have other medical conditions that make surgery too risky. That can mean they can no longer walk and they wind up bedridden in a nursing home. Parkinson's, another big one. My brother died of Parkinson's and bipolar disorder after living with us for the last 2 years of his life. And one of approximately 1 million Americans a year diagnosed with Parkinson's. And the average age is 60 when someone is diagnosed with Parkinson's. It's striking, but it's there's lots of foundations, and Michael J. Fox Foundation and others working on finding cures and treatments, but Same with Alzheimer's, but so far nothing really in the pipeline that is going to prevent any of these things. Long-term care expenses are so catastrophic that 70% of individuals become impoverished within a year of going into a nursing home. And it's not just the elderly. A big study by Unum Insurance, which at the time was the largest long-term care insurance company in the country, found that 46% of their long-term care claimants were under 65 at the time of disability. And I can tell you, in our firm, at any given time, we probably have 4 to 6 clients who are under 65, often in their 50s, who are in a nursing home because of all kinds of different things. We had 2 people in the last couple of years who became quadriplegics from falling off a ladder. We had 2 people who became quadriplegics from body surfing, of all things. I'd never even had heard of that, and we got 2 people in 1 year with that. So, it's not just the elderly. And long-term care insurance is great if you have it. If you don't have it, I recommend it. I even have an insurance company where I offer it and can help people purchase it. But less than 10% of Americans have any type of long-term care insurance. So that's not the solution for most people. One last thing I want to talk about before our break is, and we're going to take a quick 5-minute break after this slide, is taxes. There's a huge misunderstanding about estate taxes and gift taxes. And inheritance taxes. People get these all mixed up, and people think there's an annual limit on gifting, which there's not. So just to clarify this, there's a federal gift and estate tax exemption, which is just under $14 million per person for this year. Double that for a married couple, $28 million. Now that's scheduled to be cut in half in 2026, but probably won't be, given that this exemption amount was part of a law that was put into place during Trump's first term. And given that he's back in office, it's probably likely that these tax cuts will be extended, or these tax breaks for the super wealthy will be extended. So the good news there for most people is you don't have to worry about ever paying a penny of gift tax or estate tax. And the gift tax, people think there's this annual limit. There's no limit. There's an annual exemption, which this year I think it's gone up to 19,000 a year. All that means is if you give one, if you as one person give one other person more than $19,000 in 1 year, then you have to file a gift tax return. But it's informational only. You're never going to pay estate tax on that unless you give away a total during your lifetime of $14 million. So even though you may file a gift tax return, unless you've got 14 million or 28 million as a married couple, you're never going to pay gift taxes. And the people who receive a gift from you, they never pay gift taxes. People who receive inheritance don't pay taxes on the money they receive, except in 12 states. 12 states and DC have an inheritance tax. And 12 states and DC have a state level estate tax. So, and there's a smaller limit, like 5 million for DC and Maryland estate taxes. And there's 6 states that have an inheritance tax. Maryland is the only state in the country that has both estate and inheritance tax at the state level. But that inheritance tax doesn't apply to children. It only applies to collateral heirs like nieces and nephews or friends. And that inheritance tax is a tiny, tiny fraction, like 1 or 2%. It's nothing to worry about. Um, so, all right, and that's, yeah, I mentioned the inheritance tax here in the last bullet. All right, so with that, it is we're going to take a 5-minute break and let people stretch their legs, use the restroom, grab a cup of coffee. I will see you back here at in 5 minutes.